Item number 1.
One to 32.
1 to 31 are these are
What are these?
SOP matters, my lord.
Which one?
1 till 31, my lord.
1 to 31.
These
No?
are individual petitions. Serving
But then are they serving in different disposition?
water resource department.
Huh?
In water resource department on sanction post, my lord. And
All of
the
them?
my
Yes, Mr. RK General. Where's at?
Your Lordship,
It's already 28th. Now where's the affidavit?
no, we are in the process of drafting it, my lord. Because
At least one master affidavit will do.
yes, my lord, but facts, appointment letter are different, my lord. If your Lordship will permit, I will do in one matter only.
Heard Dr. M. Mozika, yes. Then it counsel for the, where's the file? I have a file.
is there.
Sorry.
1 to 31. No?
1 to 31.
1 to 31.
Dr. M. Mozika, the counsel petitioner, you should notice Mr. Advocate General with the additional Advocate General present. Such no further notice required for the state respondents. This matter simply is connected to
30th, Your Lordship.
to the
On 30th, Your Lordship. Other matter are coming on 30th.
so and so, huh?
And the 438.
Yes. So this on 30th. Yes.
30th.
The interim water plan.
Yeah, tomorrow. Yes. Next.
Mike.
Then
May it please, Lordship.
31. Now you see, where is joint petitions? I hope authorizations are there.
Lordship, it's there. Lordship.
If it's not there, then any joint petition authorization is not there.
In the other matter, there's authorization, item 45.
In number
45.
1 to 31 are individual petitions.
next 32. Authorization is here.
Lordship is there.
Same matter.
Same matter, Lordship.
Yes. Yes, heard Mr. S. Pandey, Learned Counsel for the petitioner.
This is all the 29.
Yeah.
You should notice same order, so similar. This on 30th.
30th.
With authorization was the part.
Lordship is immediately after the list of dates, Lordship.
Authorization after this of dates.
After the list of dates, Lordship.
What do you mean?
Authorization letter is annexed.
How you put it in front?
Lordship, on the last occasion, Lordship, similar matter had come up, Lordship, and
No, but you
I'm
put
sure,
it behind.
Lordship. I apologize, Lordship. On the last occasion, I was not in a position to assist the court properly, Lordship. We checked with the registry, Lordship. The authorization was there. Lordship, if Lordship can have those matters tomorrow, Lordship, is coming on the day after tomorrow,
Which
Lordship.
matter?
483, writ petition 483 and 484, Lordship.
They'll come day after tomorrow. Day after tomorrow.
tomorrow.
Yes, yes.
All right.
Most obliged, Lordship.
33. 33. 33.
May I please, Your Lordship. Your Lordship, this matter pertains to the non-releasing of the gratuity, Your Lordship. Non-releasing of the gratuity, Your Lordship.
Gratuity.
Yes, Your Lordship.
Yes, who's accepting notice? Yes, who's accepting notice?
Lordship, I'm there. For
We know you're
respondents.
there, but why you not standing up when the matter court addresses you?
Lordship.
Yes, heard, Mr.
E. Ahmed, Your Lordship.
The only gratuity, that's all working which department?
Yes.
Yes, Your Lordship. Assistant teacher, Your Lordship.
Mr. E. Ahmed, Learned Counsel the petitioner, issue notice returnable in 3 weeks. MS F. Lalu. All respondents.
All respondent, Lordship.
This on so and so.
Lordship,
For
item number
instruction
3 to 36 are connected matters, Your Lordship.
Number?
36.
Same order.
Much
Same,
obliged.
36 is same.
Yes, Lordship. Much obliged.
34. 37.
34 way.
Connected, sir.
37.
37.
Please, Lordship.
Yes.
This is the matter for non-payment of salary, Your Lordship. They are working under the Rural Development Agency, Your Lordship, in the different district, Lordship.
Which one?
This District Rural Development Agency.
Is your employment attached to the scheme?
No, this is not with that scheme. This is for
DRDA
non-payment of
is what?
salary. Non-payment of
DRDA is what?
that is
What is the
DRDA
what is the DRDA? Have you asked from your client what is the RDA?
District Rural Development Agency.
Yes.
Earlier,
What does the RDA do?
actually, they
What
oversee.
do they do the RDA?
They
What's
oversee
the function of the RDA? Answer the court.
yes.
What's the function?
Their function is to oversee the implementation of the various scheme implemented by the.
So is the employment of your petitioners attached in the particular scheme under the RDA?
Yes, Lordship.
As attached. That means they're not government employees.
No, earlier they were since from their inception they have been paying the money by the central government. Now
That's exactly what this court is saying. If the RDA, they are implementing schemes,
yes.
and the employment of your petitioners is attached to a scheme, once the scheme stops and the money flow stops, then your salary stops also. As simple as that. Because your employment is not through selection. You just appointed like that, correct?
Yes,
With
but
appointment letter.
from yes, their Lordship.
Just through selection.
Yes. The annexure, the
One.
page.
Yes, fixed page.
Annexure
at the
11, page 11, Annexure
Any
1
issue
lordship.
notice because but this DRDA is not heard Mr. P.T. Sangma, Learned Counsel for the petitioner issue notice. You have to know what your people are doing, how they are appointed. It's just us coming with a case and say I have not paid a salary.
Lordship, respondent number 3 is also agency, my lord.
It's issue notice. MS NG Shilander Senior Government Advocate, except we have 1 and 2. Notice to issue respondent number 3 within 3 days.
Lordship.
3 weeks.
Lordship, item number 37 to 42 are connected, my lord.
Same.
Same.
Yes, Lordship.
Much obliged, lordship.
43. 43.
What is this?
My lord, this is the second writ petition which has been filed by the petitioner, my lord. The first petition, my lord, which was filed relating to the rituals which was held in Lumshilong and Maunaran.
Yeah, shown him. Yes.
My lord, petitioner is the Lingdo of Ride Milim, Hima Milim, my lord. This is the second writ petition which has been filed by the petitioner,
What
my
is the
lord.
grievance here?
My lord, my grievance is, my lord, earlier one writ petition was filed, my lord, that is WPC 183 of 2025. We have approached this court, my lord, for holding the rituals at Maunaran and Lumshilong in Upper Shillong, my lord, Milim. And due to intervention of the court, my lord, the rituals were successfully performed by the people, by the Lingdo and the representative of the Sankur and Khadwekur, my lord. Now, as per the custom, my lord, the person who starts the rituals, they are the one who has to conclude the rituals at Yodo, my lord. Now, the problem is, my lord, the rituals has been fixed, the date on 10/11/2025, that is at Yodo. And my lord, the meeting was called, that is at page number 33,
Number
34, my lord.
34. Yes.
This is the meeting, my
Who
lord.
should have noticed?
This is the link score of Secretary Sankur Khadwekur, my lord. They have called for the meeting on 19/9/2025. However, we are only aggrieved, my lord, that they are not allowing this the representative who has started the rituals, my lord, to conclude the rituals at Yodo, my lord.
I don't understand.
This is the meeting, my lord, which was
This-
called.
What happened on 19/9/2020?
Meeting was called, my lord. Lingdo, he was present in the meeting, and he has stated that the person who has already started the rituals at Lumshilong, my lord, they are the one who are to conclude the rituals as per the custom at Yodo. However, my lord, they are not agreeable to that, my lord. Only agreed by that, my lord, we have come before
Who's not
this.
agreeable?
My lord,
Imam Lim.
they are the Sankur Khadwikur, my lord, the secretary.
No, who's not agreeable to
Sankur Khadwikur, my lord, they are the one who are to take part in the rituals, my lord, at Yodo.
You're not allowing them.
No.
No, who? I don't understand that. Who's not allowing you? Where's the order saying not allowing you?
My lord, there is no order.
Then?
However, after the meeting was held, my lord,
Then what's this in the newspaper?
that is, the date has been announced by the Himamili, my lord. However, the date has been
Who appears
fixed,
normally for this aim?
fixed on 18 November, my lord. My lord, notice has to go.
And Single Council the petitioner, you should notice except for this council.
This council lordship.
Number 1, Mr. J.K. Paryat, number 1, notice to issue 2. Let this Imam William appear, they will understand what's happening.
Yes.
Whether what you're saying is correct or not correct. Yes. Maybe you just see there's nothing on record to show whether you're allowed to participate or not.
My lord,
You just can't come, like just what you hear in the air.
there was no order, my lord, that was
Then if
given
something
to us,
happens,
my
we
lord.
will impose costs upon you if it's what you're saying not correct.
My lord, this is what was decided, my lord, in the meeting.
Yes, so and so, let notice to issue to respond 2 and 3 within 3 days from today. Today is the 26th or 28th.
28.
Yes, we listed on Monday.
Yeah.
You can take personal service on Imam William. Let's see if you say that.
And the other respondent is there, my lord, Sankur Khadwikur.
You serve on them.
Obliged.
44. 44.
Yes, Mr. Khashi.
My lord, this instant case, my lord, is against the impugned order of the EC, Executive Committee of the KHDC. They appoint the Lingdo, whereas it's violate the provision also because there is a CM chief also in the HIMA, and now the Executive Committee they appoint a Lingdo, which never exists a Lingdo, which is also against the provision as
Who
well.
appointed Lingdo?
The Executive Committee.
Where is that? Which page?
My lord. Page number 46, my lord, and the type copy is page number 50.
Has it gone appeal to the Executive Committee or is it unilateral decision? How does the council?
No, the thing is, they appoint a Lingdo.
We clear one thing, whether this appointment or this approval, whatever, is it at the instant unilaterally done by the Executive Committee?
Yes,
or
yes,
an
yes.
appeal?
No. Only by the
Where is
executive.
that? Let's see.
This is the order, page number 50, my lord.
That's 14 June 23. You're challenging now.
My lord, because it affects also the, because,
Mr. Khashi,
yes,
if it affected you now, over 2 years have gone, then
we have just,
it has no effect then.
my lord, we have just give a letter to the acting CM because we have heard with someone that the EC have.
Who are you?
I'm the acting Sodar of the Kendai Kentoi, Walang Kendai Kentoi. And now the EC they appoint the Lingdo of Kendai Kentoi, whereas the Kendai Kentoi falls within the Himanong Spung. And there is a chief, my lord.
So you see they appointed a Lingdo of this Kendai Kentoi.
Yes, my lord.
And this Lingdo, he's under the CM Spung.
My lord.
And he's a member of Darbar.
Yes, my lord.
You sure about that?
Yes, my lord. And
But then he's not a separate entity.
no, my lord.
This Lingdo of Kendai Kentoi.
No, my lord. And my lord, this is also a violation of which is against the Act 1959, the appointment, the United Khasi Jantia Hills, Autonomous District Appointment and Succession of Chief and Headman Act 1959, which is clearly in section 2, my lord. The chief means as aim, a Lingdo. And now within the Himanong Spung, there is a chief, and the EC appointed the lingdo. That also no opportunity to be heard, no notice was served to the
One thing it has happened 23.
Mal.
Then we will examine.
Lordship, we have not received any copies.
Why not serve copy?
I have already served, my lord.
You serve to whom?
To the their office.
To council?
Yes, sir.
We have
No,
not
no,
received.
no,
Listed on. I will list again for motion. You come with instructions.
Lordship.
my lord, the only
Heard Mr. K.S. Karshi issue notice. Mr. G.K. Parrot was present in court representing the respondents 1 to 4 submits that no notice has been, no copy of pledge is yet to be served upon the said respondents. Yes, Mr. Karshi, counsel petitioner to serve corpus court for the day. This is matter. Day after tomorrow. Yes.
my lord, a small prayer. My lord, this impugn order may
Take a
be.
small prayer day after tomorrow when you serve notice first.
Hello, Bludge.
45,
So make sure that they come with the otherwise you want any.
My lord, here therefore, my lord, this is pertaining to A&M, my lord, auxiliary nurses, my lord. My lord, very strange thing here, my lord, if lordship kindly turns to page 48, my lord. They have been confirmed in service, my lord.
Lord, this is all SOP matter. We will file and proceed with this matter also.
You issued, they've issued what?
They've confirmed the service, my lord, page 48. There is a confirmation order of service, my lord.
This is by competent authority.
But Director of Health Service, my lord.
Yes. Director of Health Services is whether competent to confirm or not will not.
Whatever it is one of your functionaries, government functionary.
But your lords will have to.
They've been given all, but this will stand differently, I think, from the other cases.
My lord, but these are.
Have they been given all the regular benefits?
Yes, my lord.
Regular employment.
My lord, the GPF, transfer posting, leave encashment, my lord.
Now, how do you see this post been advertised? Where do you?
Well, the advertisement also kindly sees page 58, my lord. In fact, they have uploaded in the official website
If
also.
they have confirmed, there's no question of advertising their
But our apprehension, my lord.
will be subject to.
My lord, that's why my prayer, my lord, lordship kindly sees, my lord, for a moment, my lord, the prayer.
No, for a time being, let not disturb your service. We'll see whether the advertisement covers you or not.
Yes, my lord.
I don't think the issue advertisement for post been confirmed. But the requirement will come from requirement department, that's a DHS, which confirmed you.
Well, we have been
if this letter is correct.
What we have been told is that, my lord, that our posts are also included in the SOP, my lord.
Who's been told by whom? Show some tangible.
My lord, there's nothing tangible. As such, if the learned advocate will come with instruction, my lord, that we are not covered, my lord, then
You can't file a writ of apprehension.
but there is a genuine apprehension, my lord. Kindly see, they don't even mention the number of posts in the advertisement, my lord. And advertisement has been issued pursuant to SOP, my lord.
My lord, the entire process will come to grinding halt, my lord.
Well,
I'm not saying the advertisement. Not saying the advertisement.
But
We
our-
just say that.
We will not disturb our service, my lord.
Heard Dr. M. Mozika, learned counsel, senior counsel for the petitioners.
Yes, my lord, for
Along
petitions.
with assisted by so and so.
this number.
Issue notice. Then Attorney General as present with so and so is present on behalf of all the respondents. No further notice required in the respondents. The grievance of the writ petitioner. The other petitions is that they are serving as
A&M, my lord. Assistant auxiliary nursing and midwife.
serving as
A&M.
A&M. That's auxiliary nursing and midwife.
Since
They call health providers or they call nurses?
health
What
providers.
is it called?
Health providers.
Yes.
Women health.
What is the correct now nomenclature? Because nomenclature has changed.
Lordship, you can see in page number 5, paragraph number 3, Lordship.
Page number 5.
Paragraph number 3,
Well,
Lordship.
appointment order says A&M, my lord. At page 34, lords, you can see.
Yes. This one, A&M, health workers. What is the number? Health workers, bracket OZ, the workers, and that they have been confirmed in service since 12.
The confirmation order is of 21, my lord.
12/7/21. However, the apprehension is that however, it is submitted that a recent advertisement has been issued on
It's dated 24th October.
dated 24/10/2022 for
25.
for the same post. Same post, but for these but however, no, sorry,
It's mentioned, no? 34.
an adjustment has recently been floated for recruitment to
Object to the adjustment.
A&M
Obsession is uploaded in Instagram.
health workers. Stop. The Senior Council submits that the repetitors are apprehensive that in view of this advertisement, their services may be affected in as much as the number of vacancies have not been indicated in the advertisement. Stated or in the advertisement. So we therefore praise that some interim protection be given. Yes. Sorry, we can stop. Next by Leonard, Advocate General, so the appearing praise are allowed to obtain necessary instructions. This case perhaps stands a different footing from the other matters which have been filed before this court, sealing the notification memorandum dated 25/9/2025. So, accordingly, this is matter after 2 weeks. In the interim, provided that the service of petition shall not be protected, shall not be disturbed the next 8 years.
And our should not be listed for filling of our post, my lord.
Yours shall be disturbed like they. Yes.
Has already protection given flags.
Ready.
They can't do the proxy litigation.
Motion, Joe. We'll have the orders next time. Sit, madam. The broken benches.
Any mention?
My lord, on joint request, we beg to mention item number 5, my lord.
Joint request.
Joint request, my lord.
What's that number 5?
It's a text matter, my lord.
GST matter, my lord.
There is an interim order as well, my lord. That may kindly be extended. And matter may be taken up
GST
after
matter,
3 weeks, my lord.
Let it come after 3 weeks.
After?
3 weeks, my lord.
3 weeks, my lord.
3 weeks.
3 weeks.
Okay.
And the interim may kindly be extended, my lord.
Interim order, any issue. Yes, Mr.
Please,
Lalu.
Lordship, I beg to mention item number 6.
Just wrong for me.
I've informed the other side also, Your Lordship. I pray that this matter may come up after 3 weeks, Your Lordship.
Okay, yeah.
Highly obliged.
Supplementary list item number 1.
King fraud.
Lordships, in this writ petition, petitioner has challenged the order and original. Order and original dated 2/9/25.
Order or show cause?
No, order. Now order. Earlier I filed the show cause. Now it is order and original.
Same petitioner filed earlier?
No, this is a fresh matter.
Fresh matter. Fresh matter.
Okay.
Fresh matter.
Where's the
So,
order?
on the ground that it violates Article 265 of the Constitution and it contravenes the Article 141 of the Constitution.
54, the order starts, my lord.
Why you say 265 source of power? To levy
265. No, because the order was passed without any provision of law. GST was imposed, so much GST, penalty, interest, without any provision of law. No provision. That is my challenge, the question of law only.
Something on source of power, that's what I'm asking. Says, that's what this court said just now, source of power. Where's the impugn order?
Starts page 54, my lord. The operative part is page 67. It's a 14 lakh rupees demand, my lord.
1 second.
No, 14 and 1 crore.
60?
67.
67. I confirm the demand. So this one?
Yes, yes, my lord. 67.
Yes. Why you say there's no source of power?
Because no provision of whatever they have proposed, that is at page 95. One notification, RCM notification, 13/10/2017. It is not applicable for seized.
Here what happened, my lord, the seized coal were auctioned by the deputy commissioner's office, my lord, 3-4 years back. And they were the bidders who got that auction, my lord. Now it appears that they have not paid GST on that, my lord.
You have to pay GST on that?
Well, 5% GST is applicable.
But then here, you seize and confiscated goods.
But here, my lord,
don't come in exemption provided to seize goods. Because as it is, GST has to be levied on every transaction.
Yes, my lord.
And who should bear the brunt then?
But actually here what should happen is the deputy commissioners would have collected GST from them, my lord.
Yes.
They did not collect.
They should have added that to the auction value.
It appears it's added to them, my lord.
Then how can you saddle them any liability now if they come then exemption provided by your notification itself?
But I'll have instruction file affidavit.
Seize goods is confiscated and seized. All that coal has been sold illegally mined, has been confiscated, seized, kept in those stockyards and
under the order of the magistrate, my lord. These were confiscated and auctioned, my lord.
Then
I'll have instruction on this as well. I'll file an affidavit. What is the correct picture?
Never confiscated. It is only seized.
Seized. Whatever.
Yes,
confiscated, seized. Same thing. Incidents will fall on whom? Whether this amount has to come from that environmental restoration fund. Because from the auction amount,
yes,
a percentage is already levied,
yes,
for environmental restoration fund, which goes into the and that also is under the what that committee is called, the oversight committee is there that looks out the spending of this money or the
But GST department, they took it a very simple transaction, my lord. The the deputy commissioner's office is selling the coal to them, so they should collect GST from them give
But
the
did you ever issue such notice to the collector that you having this seized thing and this is a transaction comes from auction that you should add on that factor in that cost not auction
But
amount?
it appears the GST, the DC office is not GST registered, my lord, and they don't comply with GST.
There'll be a problem
GST
then.
law.
They have to have a they have to have a number.
My lord.
Then how will it be into the portal if they're not
Because they are not a
registered?
business entity as such. my lord. I'll have instruction file.
Have you stay this order for the meanwhile?
No coercive action for the time being.
Yes. Heard Mr. N. Zugutta, learned counsel for the petitioner. Issue notice. Dr. N. Mozika with so was present on behalf of the respondent. As such, no further was required. The respondents of the grievance of the writ petitioner. Or the petitioner has assailed an order dated
29/25.
As being without jurisdiction and violative of Article 265 of the Constitution of India. Mr. N. Zugutta submits that the transaction in question relates to seized coal.
Yes.
Which, as per the notification dated 13 October 2017, comes under the
Seized and confiscated.
Yes, comes under the. Where is it written?
3.
Yes.
Page number 95. Used vehicles, seized and confiscated goods, old and used goods, waste and scrap.
This comes under the exemption allowed to seize and confiscated goods. Stop. He further submits that
it also contravenes Article 141.
We will not say that. Yes, he further submits. He prays that as the imposition of GST has been on the seized coal, the impugn order may be not be given effect to in the interim. Stop. Next, by Dr. N. Mozika, learned ESGI, which also for the respondents has submitted that on any transaction, GST is compulsorily payable. However, in instant case, he prays that he be allowed to obtain necessary instructions in this regard. Stop. When should we list it?
3 weeks. 3 weeks.
3 weeks. According to this matter, after 3 weeks to await instructions or affidavit. In the meantime, the impugn order shall not be given effect to until next day is. Much obliged.
Daily list item number 1.
What is this, Mr. PT?
This is the miscase application I have filed for contradicting the delay, Your Lordship. The private respondent, they have filed an objection I have just received today. And I don't know whether.
How many days delay?
There's a
1,645 days.
That's all. Yes. So, you want to have another day to argue with?
Yes, Lordship.
Yes. Mr. P.D. Sama submits that the objection to the coordination application filed by respondents number 3 and 4 has just been received. We praise the matter be taken consideration on?
After 2 weeks, my lord.
After 2 weeks, okay, after 2 weeks.
Hello.
Yes, yes.
Much less, Lordship.
Item number 2.
May I please, Your Lordship?
1 second. Just
Lordship, we filed the status report, my lord, affidavit on 15/10/2025, my lord.
The respondents 7, 8 and 9 have been served?
Yes, my lord, but not yet appeared, my lord. It's on the
cases. When were these served?
My lord, the copy has been served on, my lord, 23/9/2025, my lord.
Mr.
I'm appearing for the state respondent.
The delay is quite substantial, Mr. Hassan.
My lord, our total delay is 770 days, but actual delay is 119 days, my lord.
Why do you say that?
My lord, because 650 days are in the, my lord, legal proceedings, my lord. After the passing of the impugn judgment in writ petition number, my lord, then file a review, my lord. After a review was dismissed, we file an appeal.
So it was before another forum.
Yes,
that's
ma'am.
your excuse.
Yes,
but actual delay is how many days?
Actual delay is 119, my lord. maybe excluded the 650 days, my lord.
119 days. What were we doing 119 days then?
My lord, because the petitioner herein, my lord, is she having a child, my lord, of 2 years child, my lord, and she's from Garo Hills. She instructed her lawyer, previous counsel, to get this certified copy. Then after that, she met her lawyer, and my lord, after that
We'll do one thing. You have any objection?
Lordship, on my part, I have no objection, Lordship. But
anyway, we just
maybe respondents, Lordship.
Let's give them one more chance to enter appearance.
Lordship, as per this delivery report, the notice was delivered to Rajabala box office, not to the addressee, Lordship.
No, is that correct? Delivered on, my lord, at annexure, my lord. In the affidavit, date of delivery is 23/9/2025. The letter issued by the post office, my lord.
What to issue branch post office?
My lord,
delivered to box.
Yeah, that's
Rajabala box office.
Branch office.
My lord, the delivery address they have mentioned, my lord, in the letter, my lord, because this is how we write to the post office, and they used to issue the letter, my lord. The delivery status.
Your delivery address is Rajabala High Secondary School.
Yes, my lord. Yes, my lord. The Sonia.
Can you affect dusty service because it's a matter of condemnation?
My lord, yes, we can, my lord.
Yeah, I think better you affect dusty service.
Let them come and appear. My part, I don't have objection.
An affidavit indicating factum of service upon the respondent 7, 8, and 9 has been filed by the applicant. So, however, Mr. H. Karami, learned additional senior advocate, has submitted that the report shows that the notice was served upon Rajabala branch office and not on delivery address indicated therein. So he just stop next paragraph. As the delay is substantial, and in view of the uncertainty about the service of notice, let the applicant effect notice by dusty service upon the response 9.
Yes,
in the interest of justice. Yes, just after 2 weeks. Steps were taken within, then the report to be filed.
My lord, within 3 days, we will take. Highly obliged.
Item number 3.
Yes, Mr.
May please, Lordship. Lordship, received a copy of the rejoinder, Lordship. This matter may be listed for hearing, Lordship, on.
My lord, we have given the rejoinder on the 16th itself.
On the
16th itself, on the last date of the hearing itself, 1 day before. And this date was kept specifically. They have raised 2 grounds on that. So we have only been reverting to that ground. This is
what are the 2 grounds that you filed rejoinder?
They have raised the ground of maintainability of the writ petition on the ground that the association is not registered. Whereas the association is registered, we filed the documents. In fact, on the previous round, when we filed the writ petition also, we've annexed the letterhead where the numbers and all are there.
And what's the next ground that they've
The second ground, my lord, is saying that we do not get the benefit of Article 14 and 19 because of the trade, which is restricted commercial.
That's correct, yes.
Number 3, they are saying that this is a trade where the government has a right to impose whatever, because we are not anywhere challenging their right to impose this tax. We are only saying that you have a right to impose it, but not take away my profit. So I would like to address your lordships only on the ground.
What was the amount involved? I mean, the percentage.
Initially in 2017, when the notification came out, my lord, it was 20% of the profit margin. Subsequently, now in 2025, in 12th of September, they have come out with the notification reducing that profit margin to 15%. Our grievance is that we have no problem with the system.
Whatever mechanism or device they're putting in place will take 5% of your profit.
Yes. And in fact, my lord, I can give it on statement because I did speak to my clients yesterday. What they are doing now is that, my lord, the price which is existing on the previous rate card is still existing. But because of they want to implement the project, they have got the manufacturers have been told to bring in the new price that has been now sent to the central bond, as well as to us. We are selling it only to implement the project, but there is no scanning, because we can't scan it because we are still in the process of registration. Implementation can, my lord, only happen once you notify the scheme and it has to go live. None of that has happened.
You mean to say imposing the cost now without the...
Yes.
Is that what you're submitting?
Yes, and that's on instruction. I asked them yesterday. He said, we are selling it because it has come to us.
How is that possible?
That's what is happening, my lord. They are there to correct it. And this is a statement, and I asked him. He said, we are selling it. The new prices have come. I have got pictures. I have taken the pictures and got it. The price has already been done because the cost card has been approved by the department and sent to the manufacturer. Manufacturer has to do it. But the implementation of the scheme can only happen once it goes live. Now I'm selling it. I'm selling it at the price which is revised. I have
How
the
is that
bottle.
possible?
That's what we are doing, my lord. And that's the difficulty I'm facing today. I have it to show what is the previous price and the price which is going on right now, my lord. And I'm selling it, but you can't implement it. They have not gone live. They have not notified the scheme.
And they're extracting the revenue.
Yes, I have lost this, and this is a peculiar case where the excise has decided not to put it on the end consumer, but introduce a scheme, enhance the revenue by taking my profit. That's anyway not available.
That's what you came up with first.
Yes, but that is something, my lord.
Certain percentage, and that by implementing the sticker and this QR code, that whatever cost involved with that's being taken from the retailers.
Yes.
Correct. That is your grievance.
Yes.
Now we're saying without the entire scheme being put in place,
we are selling it.
QR codes are not there.
Yes.
And then you're compelled to sell it. That
I have to, because they're giving it to me.
So you're passing on the cost to the consumer. That means
yes, on a scheme which is not supposed to do that. And prices have already increased. I have pictures of everything. I bought it on the
put an affidavit.
But my lord,
the thing is that Mr. Fukan, we just now remains oral submission. You put an affidavit. We'll have it next week itself.
There's only 2 working days on the next week. So, my lord, I don't know.
For Lordship, the Lord Advocate General will be leading the matter.
Let him come, but all I'm saying, my lord, is that the new price list has still not come. So, I'm saying, my lord,
they're already extracting my money. Mr. Fukan, that is very alarming.
That's
because if
I have taken instructions specifically to this effect. No, I agree, my lord.
What do you call it? Is not up and running, and how can the revenue be extracted?
I mean, they're in a better position to assist your lordships, but I can tell your lordships till the day the rejoinder has been filed, and I have taken a specific ground. They have not notified the scheme. You cannot run a scheme without notifying, number one. Their own notification says that it has to go live onwards. You can't go retrospectively. So you can't do it. So the price which has now come, I have to sell it because I have to run my business. The question is, the business says that I have to scan everything, starting from the circle that starts from the settled bond. Everybody has been forced to sell it because it's come to them. What do? Price is on the bottle. I can't sell it in the previous price. No. And it's a trade which is in a complete anarchy. People are saying that we are selling it because we have to sell it. Either protect me to that extent, my lord, at least.
Yes, you put in a small affidavit. Whatever you're submitting now, that is the scheme that's not gone live.
Yes,
and the revenue extraction has started.
Right,
and which you're passing on to the consumers.
Yes, I will put in an affidavit. Because
you record Mr. RB today submitted that in spite of the scheme not yet being notified, new prices have been issued by the manufacturers, wherein the 5% cost has been factored in. He submits that in view of this development, the retailers are compelled to sell and produce at the new rate. Next time, he is directed to put the same on by way of affidavit. This is the matter on 4th of November.
Is 6th working, my lord?
6th.
Yeah, after 4th we are. Mr. Sen is here. He's eminently capable.
There's another small issue, my lord. I just wanted, there are certain additional documents that we have got through filing an RTI.
No, we want your specific submissions on this point.
No, I will file that. All I'm saying, my lord, is that
price and the price that's fixed on the
yes, I have that.
Otherwise,
I have it on record.
That is a very, very critical issue.
It is. I'll do that, my lord. The only thing I wanted to impress the lordship is on the last occasion there was a statement made by the learned Advocate General saying that the 6% which has been given as a profit margin to the central bond was in terms of actually a judgment that has been passed by this honourable court. So the notification, the amendment that happened on 44 was not in terms of this amendment of which happened on 12th of September. It is not in the terms of the scheme. The amendment happened in terms of the direction given by the division bench that they said that you should take care of the profit margin because that was not available initially. 8% was given to the state. The central bond was given 6%.
That is in the light of within the central.
Yeah, but that was projected, my lord, that it is to be equally divided. No. The entire burden ultimately has been taken from me. It's not gone to the bond house. In fact, this 5% has gone out from me and gone to them.
No, that's your case only. That is going out from you.
Yes.
But the thing is that 20% is not a fixed margin, is it?
It is. That's by a notification in 2017.
No, the 20% doesn't mean that what side price you sell the bottle is it fixed totally.
It is. In fact, I asked them. I thought that
they give from the central bond.
I asked them that would there be a variation in the price in the profit? No. It's 20% flat, 15% flat.
Right.
So I'll put it on affidavit if a lordship wanted.
Yes.
I'll just
list on 4th.
Hearing.
Or you don't list on 4th. You can tell a suitable date, which is.
I'm extremely grateful, Your Lord. May I just file that RTI also because it's extremely important.
File it.
I'll extremely grateful.
I'm also permitted to file additional materials necessary for adjudication.
Yeah, grateful.
Your Lordship, on the last occasion, I have submitted a list of cases for 23. And this 123 is triggered only when the goods are seized under reasonable belief. In the instant case, there is no reasonable belief has been demonstrated. And the existence of reasonable belief is the fundamental requirement of a lawful seizure under Section 110(1) of the Customs Act. And it is also pivotal on which the burden of proof under Section 123 shifts to the person concerned. In this case, seizure was made by the RPF, Railway Police, who deprived the petitioner of his property.
What is the quantity of gold?
4 kg.
4 kgs.
Yes, yes. Who deprived the petitioner of his property without reasonable belief. Hence, the burden of proof.
Again, you are talking a burden of proof in 123.
123, yes, my lord. Because no reasonable belief in this case. So, I may refer the cases of writ petition. '75 page.
Where is the citation? You provide.
No, citation I have given. That is.
Oh, yes.
I am referring first Ganchand case, 1983 ELT 13 1365 SC.
Which page from this compilation?
Page. I am reading from appeal petition. It is already at page 75. First, this High Court order.
75.
Page 75.
Dr. Muzika, have your submission you have not concluded?
No.
We'll do one thing. We'll post another day this one. It's a bit pressed for time due to some other.
But we are at a stage of second appeal now. But this is a
Oh, yeah. Questions of law have been framed.
No, not framed, my lord.
Why?
Question of law not framed.
It is on that question.
Yes.
What questions of law to frame?
So it was on burden. Whether.
But what Mr. Dasgupta is submitting, my lord, that is the initial protection at the time of seizure, my lord. Now, after that, a lot of water is flown down the bridge, my lord. Now, it has been established that these are smuggled golds, my lord.
Only 3 questions may be raised, my lord.
Suggested questions.
No,
it is there.
No, you have filed your suggested questions of law.
Yes.
You have not filed them.
For me, my lord, there are no questions involved, my lord. I'll counter the questions with them, my lord. Suggest with them.
Oh, then why does it come for hearing then?
Yes, that's why I say.
Okay, we'll consider. It appears that the questions of law are yet to be framed by this court, as the matter is effectively a second appeal against the order of the Sestat. Right?
Yes,
Kolkata. According to this matter in order column on when?
After 2 weeks.
After 2 weeks, yes, for framing of substantial questions of law.
Okay, much of this.
They should have told that in the beginning, Mr. Dasgupta, that the
Yes,
questions of law have not been.
but your.
Then once they have framed that, we just stick to the questions of law.
Yes,
that's all. Then we don't have to go and run. I mean, like, dwell with the facts.
Much of this.
Orders.
Daily list item number 1.
Yes.
Please, Your Lordship, item number 1 and 2 are connected matters. 2, I'm the appellant. I was supposed to file an application, a memo of, to amend my memo. It's despite instructions the client has sent the signed copy.
But why is it recorded in this order?
My lord.
You're supposed to file an application for amendment.
Yes, my lord.
Then?
So we received it despite our instructions, they did not get it notarized. So we've asked them they're coming today. We'll file it by tomorrow, my lords.
Don't record in this Kanika first one. Record in number.
Item number 2. 6.
Number 6. FA6. Number 6. Mr. SN, please phone allowed. Further, 1 week's time to file an application for amendment. List on so and so. Number 1 list together with so and so. Not sure.
I'll oblige.
Item number 3.
Just okay, covering the form.
Your Lordship, my senior will be appearing through BC.
We can't see her. Where? What's the matter about?
Service matter.
Service matter, yes. What's the matter? What is the concern? You have the brief with you? No. When do you have it, MS Mitcham?
After 2 weeks, Lordship.
We'll have tomorrow?
After 2 weeks.
After 1 week. You're informed. Your counsel.
I don't know.
Having counsel for the petition not present is the matter after 1 week.
Item number 4.
May it please, Your Lordship. Lordship, in this matter, I'm praying for 2 weeks' time, Your Lordship, to file the objection, Your Lordship.
How many times you've prayed?
This will be the second time, Your Lordship.
4, 5. No. I think we'll close the objection.
Lordship, yes. We'll close the matter only.
Unnecessary. What's the point of every time you all seek time? Everything.
No, Lordship, the
inquiry committee also has already expired, Your Lordship.
What to do?
Lordship, 2 weeks may be granted, Your Lordship. We'll file the objection, Your Lordship. It's almost ready. It's almost ready, Your Lordship.
Let's see it.
Lordship, soft copy, Your Lordship.
Soft copy. Okay, you print soft copy at 2 o'clock. Okay. You see, we are taking Stephen the bar. Lawyer is supposed to be truthful. It's ready, right? You said.
It's almost ready.
So you print the soft copy. We'll just take the matter up at 2:15. Okay.
Lordship, after a week, Lordship. After a week.
So it's not been prepared. That means.
Has been prepared, Your Lordship.
Soft copy means inside. Here or in the computer? Where?
See, Lordship. Computer.
Anyway.
Lordship, yes.
After a week, there's a lot of opportunity for objections by the
4 and 5, Your Lordship.
I see.
4 and 5, Your Lordship.
Next time, if you say ready, then we'll ask for 1 hour. Just you go to your office and bring it.
Get it now.
Item number 6.
Apply, Your Lordship.
Were you joined this file?
No, Your Lordship. There's some defects in the rejoinder, Your Lordship, so we had sent for signatures again, Your Lordship.
He's appealing for whom? Mr. Chaudhary?
My Lord, I am for respondent number 2, my Lord.
Respondent number 1.
Bring for 2 weeks' time, Your Lordship.
Why?
There's some defects.
You also already in the computer?
No, Your Lordship. There were some defects in the affidavit.
Yes, last opportunity, okay. The 3rd time asking?
Yes, Your Lordship.
Yes, last opportunity of 2 weeks allowed for rejoinder. Just thereafter.
7.
May it please, Your Lordship. Lordship, in this matter, we are supposed to come on instruction, Your Lordship.
With the?
Instruction, Your Lordship. Lordship, whether to proceed with the matter or not.
But
instructions are with my senior, Your Lordship. So I pray that the matter may come up next week, Your Lordship.
What are the instructions you have?
Lordship, it's with my senior, Your Lordship.
He doesn't tell you what instructions he received also, verbally.
Your Lordship.
Top secret.
No, it's not like that, Your Lordship.
No, yeah, you're pursuing the matter or not?
We are pursuing, Your Lordship. But Lordship, because on the last occasion they say that the matter is infructuous.
It's not infructuous. For certain portion of a tender, where there are two tenderers, that has been settled. But where there's only one, they will re-tender it. So that's we are taking instructions whether you're interested in pursuing the matter or not. But it will not cover the now since the tender matter is settled. Not just what pleadings you have not cover the new development. That is the thing.
Lordship, let it come next week, Lordship.
2 o'clock.
Next week, Lordship. Any date convenience to your Lordship.
Mr. S. Kriam submits that no instructions have been received the same with his senior. We have not divulged the same to the council, right?
Sure.
Then?
Instruction, Your Lordship.
Yes.
Much obliged.
8.
Lordship, we have filed rejoinder, Your Lordship.
You filed?
Yes, Your
We've received it yesterday, Your Lordship.
We will post it for hearing?
Yes, Your Lordship.
Yes, the parties submit the pleadings are complete. List the matter for hearing.
After 2
weeks.
Obliged, Your Lordship.
9.
My lord, it can be disposed in view of the affidavit filed by the state respondent. This is a case of disability pension, Lordship. My lord, if my lord will see the affidavit of the state respondent, that is at para 8 and 11, Lordship. Para 8 and 11. Para 11 is important, Lordship. Because my case is covered by Rule 48 of the Meghalaya Civil Service Pension Rule. May I read, Lord?
Para 8.
Para 8.
Yeah.
That the Deputy most humbly submit that he received a reply which is mentioned that the disability certificate is verified and authenticated by letter number so-and-so, dated so-and-so, issued by Dr. C.R. Marak, Nodal Officer, District Resource Center on Disability Affairs, Tura Civil Hospital, and it is found that the concerned individual writ petitioner has been thoroughly assessed by a qualified specialist doctor at the Tura Civil Hospital, West Garo Hills. Following the medical assessment, the certificate has been authenticated and verified for accuracy and completeness. The verified certificate has been duly updated and recorded in the official portal of so-and-so website for necessary action. Lordship will find para 11, Lordship. Then the deponent most humbly submit that there is no objection on the part of the concerned respondent department considering the genuineness of his disability in granting the family pension of his mother late so-and-so who died on so-and-so, leaving behind the petitioner who is a mentally retarded person dependent
Who drafted
on...
the affidavit?
Myself, Your Lordship.
You know that it's not politically correct to use words retarded now.
Yes.
Because we see this Mental Health Act has gone into is a change after 87. There's a new act now also. Can you please correct it? It's not this challenge. Not a certain
Yes,
terms
sir.
that you use now, which is not
Changed
acceptable
already.
anymore. Yes.
Yes, sir.
But in the service rules that 1983
Doesn't matter.
remains the
Because
same.
it is,
This is for the old.
Yes, yes, Lordship.
Act.
Lordship.
Your Lordship, one submission in para 10, otherwise it is perfectly, his pension can be granted to him, but only thing is this, his date of birth is not matching, and para 10 of this affidavit I have stated.
When did he go to school at all? No.
No, Lordship.
Because as per the other certificate he is 71, but as per the birth certificate, Your Lordship,
That
his
will produce
date of birth
before the
is
authority, Lordship, if there is any
64.
Aadhaar card
71. 71, Your Lordship.
And government of India.
But and birth certificate is
birth certificate. Birth certificate. What if
Well, birth certificate.
birth certificate I have attached here, Your Lordship. Next page, page 10 of the affidavit. Yes, Your Lordship.
That will correct it, Lordship.
Yes, then
That
correct date of birth is.
30th 6 1964.
Then you adopt this one. Yes, Mr. S.E. Sheikh submits that on the affidavit being filed by the respondents. It appears that there is no more impediment to the grant of family pension to the writ petitioner. The council have drawn attention to this court to paragraphs 8 and 11 of the affidavit, which is reproduced here and below. Next one, MS S. Barachaji, learned government advocate, to not disputing the position, however, submitted that there's some confusion with regard to the correct date of birth of the petitioner, as in the Aadhaar card it is shown as 1971.
1971.
Being born in on only year. You didn't even give the date. Only the as per the UID card. The bracket unique disability ID card is shown 71. Whereas in the birth certificate issued by the Registrar of Births and Deaths,
Southeast Garowe,
Mahendraganj, CHC, Southwest Garowe, the same is shown as 36/1964.
30/6/1964.
Yes, that's another form. This court has heard the council also examined the materials. Accordingly, as per the affidavit, which has been reproduced here and above, it appears that there is no impediment to the grant of family pension to the writ petitioner, and it seems accordingly directed to be processed and disbursed at the earliest stop. With regard to the date of birth, it is noted that in UID only the years given stop, as the more accurate representation has been given in the birth certificate. The date of birth, that is 36/1964, as sure birth certificate shall be taken to be the correct date of birth. So with above, as ordered above, matters stand disposed of.
Some directionally and
Disposed of with the further direction that the process should be completed within 3 months and pension disbursed thereafter. Yes.
Item number 10.
Yes, where's that person?
His presence.
What is the problem?
Sir, I'm the
yes,
sir. I'm the officer in charge of the employee, and we are processing his documents, sir. We are affirmative, positive to give him pension, sir. And thrice we processed case to the PCDA Allahabad, sir. That is a pension sanctioning authority, sir. But they returned finally with the observation that the disability should be during the lifetime of the parents, sir, according to CCS Rule 72, sir. That's what we intimated claimant also, ki submit any document wherein it shows that that disability of illness is during the lifetime of the parents, sir. And once we get that certificate or any medical document, we'll again submit the claim and he'll be
stuck at that stage, you mean?
Sir, sir?
It's stuck at that stage, that's why you can't process the pension any further.
Yes, sir.
Or has it gone forward now?
No, sir. Now
the thing is that, see, it's the nature of, you know, the medical condition is suffering from.
Exactly.
It's lifeline.
Sir.
It's lifelong. So can't it take into consideration that fact? We will order that you clear it. Yes.
Sir, once we get us any medical document, sir, we'll be submitting claim. And
why subjecting them to such, you know, harassment, in the sense that he's mentally challenged, correct?
Exactly. Yes, sir. Thrice we submitted the claim to PCDA Allahabad, sir, and my office is affirmative, positive, sir. Again, I am approaching the claimant also. Okay, give any document which.
Can you get a document?
My lord, with respect to my officer submission, my lord, my only humble submission is that in page number 55, my lord, point number P, disability certificate dated 13 September 2022, issued by the medical authority, East Khasi Hills Department of Empowerment of Person with Disability. That has already been submitted, my lord. All the documents.
Where is that? At serial number?
My lord, page 55, my lord.
Serial number?
P.
22.
Yes.
During the
yes.
lifetime of the parents.
My lord, this assessment, it was, my lord, it is an admitted fact that he was already
No,
disabled.
see, what they're saying is that as per the rules,
Yes, my
you
lord.
need to have a certificate showing that he suffered from this disability during the lifetime of his parents, correct?
Correct, my lord, yes.
But then this is 22 after the death, correct?
Yes, my lord. My lord, there is a medical certificate also, which is at page number 100, that since 3 years old, my lord, he is suffering from prof schizophrenia.
You show something that shows it's a lifelong condition, then we'll pass the order.
My lord, the medical is already there from the
Where's
board,
that
my lord.
page number?
Page 100 is there. This is a type copy of the medical certificate, my lord. This is from Civil Hospital, medical certificate, my lord.
Yes. You take this into consideration. We'll order who's the CRD? Mr. Debnat.
Yes.
You are paying for the other pension authority also, correct? Respondent number?
Your Lordship, this others Assam they are not.
No. See what the officer is saying. Yes. That they 3 times they have written to these. What is this one? Is that?
This CDA Allahabad.
The number 6. You are representing them, correct?
Yes.
It's a PCD Allahabad, sir.
Yes,
yes.
Your prior branch. You are representing them, correct?
Yes.
Then, what is your name?
Sir, I'm Lieutenant Colonel Vishwas Bhosle.
Yes, Lieutenant Colonel Bhosla.
Bhosle Vishwas.
Vishwas. You are the respondent.
I'm CRO Assam Records.
Who's the CRO? Chief Controller of Accounts or Chief Controller of
Record Officer, sir.
Chief Record Officer of Assam?
Assam Regiment.
Assam Regiment. Yes.
Has appeared today as directed by this court and has apprised this court that the non-grant of the disability or the family pension in respect of the petitioner, who is the handicapped son of late Shri so-and-so B.I.G. Nath Tiwari, is due to the fact that a disability certificate showing that he suffered this ailment during the lifetime of his parents has not been produced. So he submits that 3 attempts have been made by the respondents whom is Lieutenant Colonel appearing. Respondent number?
Respondent number 4, my lord.
That'll be number 3.
Number 3.
Yes.
Yes.
In spite of 3 of attempts being made by respondent number 3. That is the records officer. The respondent number 6. That is a principal controller of defense accounts, pensions, prior grants, have not acceded to the requests on the ground that the disability certificate, that there is no certificate showing that the claimant was suffering at the time of the death of the parents. Next paragraph. Then counsel for the petitioner, legal counsel, correct?
Yes, my lord, I'm legal
for the petitioner has however drawn attention of this court. Where's that? Page 100.
Page 100, my lord, yes.
Medical copy which is typed, wherein it is certified that the claimant had been suffering from schizophrenia since the age of 3 years when his father was alive and was under his treatment. The certificate has been issued from an
Civil Hospital.
So no, it's been issued by the senior neuropsychiatrist in charge of psychiatry department, Civil Hospital, Shillong. Which he therefore submits that in view. This submits that on the certificate, perhaps the respondents can process the case of the petitioner expeditiously. Mr. Debnat, anything to say? Yes. No. Next paragraph. On examining the materials, on hearing the clarification given by the officer concerned. Number 3.
Your Lordship, this certificate is not satisfying this disability certificate given by this.
But
doesn't matter. On him, the clarification given by the concerned officer on behalf of number 3, and also the counsel for the petitioner. It is therefore directed that the respondent number 6 shall take into account the medical certificate issued by so and so earlier on, certifying that the claimant had been suffering from schizophrenia since the age of 3, which means that at the time the parents are alive, the claimant was suffering from this disorder. This point number 6 is directed that Council point number 6, Mr. Dabna, directed to convey place copy of this order before the said respondent for expeditious compliance. Yes, please, after 6 weeks. Yes.
My lord,
So
after 4 weeks.
Where's the rejoinder?
Lordship.
Even the, how many times have they sought?
I think they've sought twice.
This is the third time.
This is the third time.
If none appears for the petitioner, rejoinder is closed. This is the matter for hearing.
Wait for Lordship.
12.
Yes, my lord.
That was the order.
My lord, this Miss case here was.
Yes.
Yes, my lord. This is a football matter, my lord. In this Miss case, my lord, I just seek redressal because, my lord, I was not heard on the date that they called for.
They're expanding the prayer
Yes, we are,
of
my
the
lord.
writ petition by Miss Case. They can withdraw this and file afresh if they desire.
Yes,
We'll do
withdraw
that. We'll do that, my lord.
Yes, MSOI Bank submits that as the current, as the developments are not covered by pleadings or instant petitions, he prays without to withdraw the same and file afresh if so advised. Yes, prayer is allowed. The deputy has prayed.
13.
Matter stands for withdrawal. Deputy has prayed. Prayer is allowed. Matter stands for withdrawal. Deputy has prayed. Affidavit is filed.
Lordship, on behalf of the state lordship, we are praying for some more time, my lord.
6.
Lordship, I am also praying some more time.
Why?
Lordship, the RPFC officer has retired, Lordship. We are waiting for new appointment.
No one's been appointed as yet.
Not appointed.
Yes, as prayed for the 2 weeks' time, allowed to respond to 5 respective affidavits.
Much obliged, Lordship.
14.
Your
Please,
lordship.
They filed their.
Where's the affidavit?
They filed yesterday, Lordship.
You filed yesterday? Yes, so you want to
Allow
rejoin
some
the
time,
owner?
Lordship. We would like to, Lordship. Allow some time to take instructions, Lordship, before.
Mr. Kharkaran, I praise them allowed 2 weeks' time to file rejoinder.
Lordship, some instructions first, Lordship, because.
Please allow 2 weeks' time to seek instructions if rejoinder is necessary.
Obliged, Lordship.
15.
If necessary, the same should be filed within 2 weeks.
Lordship.
May it please your lordship. Lordship, I'm praying for some more time to file up my rejoinder affidavit, lordship.
How many copies
This
have
would-
been granted?
Lordship, this would be the second time.
Yes, you have any objection?
No objection.
Who's number 3?
Lordship, UGC.
Where's number 3? Yes. They file affidavit.
No, lordship, they're just formal party.
Okay, Ms. K.D. Cruz, you're legally counsel.
Lordship.
Place of allowed 2 weeks' time to file rejoinder.
Highly obliged, lordship.
16.
May it please your lordship. Lordship, I'm praying for 2 days time to file my affidavit, my lord.
There is only one basic issue which need to be decided by this honorable court. We have filed a representation. On the representation, we have raised the grievances that my juniors are getting more pay than me. Only to dispose of the representation, my lord.
Why are you getting more pay than you?
That is the clarification we seek from the department.
After your promotion, you got less pay than your juniors.
Yes, my lord. That is the only to dispose of my representation, my lord.
My lord, the reason is because, my lord, those ad hoc employees, my lord, they were given increment for their long years of service.
That may be a reason, but what is the difficulty or why they are feeling
Since you
shy?
already approached the court, let them. Why
This time we'll bring all those.
File affidavit, we can settle the matter.
My lord.
Yes, as prayed for the 1 week's time, allowed to learned GA to file affidavit.
Team name, right?
17.
Where's Mr. Pandey?
He's not here, Your Lordship.
Who's the foreign petitioner?
NM Karsham Lang, Lordship. They're supposed to come up with
Yes,
instructions.
because the pension's been paid.
Lordship.
This is matter tomorrow. As a council of petitioners absent. We take up hearings at 2 o'clock or 2:15. Yes.
But
mention.
Yes, but item 32, my lord.
I can give you. I have to give you that liberty because the dislocation and benches today.
Yes, Lord. Lord, item 32, we have just filed a rejoinder this morning. So kindly have it after 2 weeks, my lord. We've just served them a copy, my lord.
Lordship, we have received.
Okay, and the request 2 weeks. Yes, 32. Yes.
My lord, 23 and 24, my lord. Kindly have it after 2. I informed also my learned seniors, my lord. After 2 weeks,
Which
my
senior?
my lord, the other side, my lord.
23, 24.
Yes, my lord. After 2 weeks,
Objection.
Sir, 23,
Yes.
24.
23, 24.
Yes.
My lord. Interim order may continue, my lord.
Tomorrow they continue. Yes.
My lord. Highly obliged.
May please Lordship.
Any more mention?
Yes, Lordship. Item number 19, 25 and 29, Lordship.
19?
19, 25 and 29, my lord. I have informed to all the parties, Lordship. They are there.
In 25, I am appearing, my lord.
Your objection, Mr. Nongri?
No objection.
25 and 29.
29, I have informed. They also
Yes, sir.
scheduled request.
Okay, after 2 weeks, yes.
Lordship. After 3 weeks, Lordship.
Yes. For 29, Lordship.
For 29, no objection. Lordship.
Yes. That's it.
Please, Lordship, item number 30.
Do some matter is 2 o'clock. Why?
Lordship, I have some personal urgency that
I want to go to the council now.
I beg your pardon.
Want to go to other courts now, yes. What item?
30. 2 weeks.
Yeah, 2 weeks, yes.
Highly obliged.
28? Ready? Who has been?
27, 28, we are only filing our written arguments. Why not we can file it now?
What about the state?
States also.
Lordship will be filing, my lord.
Also today?
Lordship.
Lordship, we already prepared our written submissions.
You ready for today?
Lordship, we've already completed with the...
Today.
We're filing it today.
Or not?
We're filing today, Lordship.
Is you positive 100%?
Filing it now only.
We're filing now, sir.
Send them to going 728. Yes, sir. Yes, sir. Hearings concluded. Judgment reserved. Yes.
Lordship. Lordship,
Population.
Yes. That's it.
My lord, I beg to mention item number 21, my lord.
Yes.
Let it come up after 2 weeks, my lord.
No objection.
Yes.
And my lord, 20 as well, my lord.
20 also?
My lord.
You have objection on 20?
No, 20,
No
my lord.
objection.
May come up tomorrow or day after, my lord.
If you adjourn it, adjourn for 2 weeks. If you want to do it, you do it.
My lord, may fix it next week, my lord.
Okay, after 1 week. Yes. Yes.
Lordship, I beg to mention item number 22.
Your objection, Mr. Nyota?
No, Your Honor.
What happened to the title suit? Order's been passed.
He speak on Friday, Your Honor. This Friday for
It's
judgment.
this Friday?
Yes, for judgment.
Order for judgment title suit?
Yes.
Then we'll list out for 2 weeks then.
Okay.
Yes.
Obliged.
Pray the parties. Join prayer after 2 weeks. Yes.
Your Lordship, item note 26, this matter may be listed after a week, Your Lordship.
He has objection, correct?
Otherwise, we were ready, Your Lordship.
Then we'll do it.
This Lieutenant AAG is on leave today.
Who's AAG?
Yangi, she's leading this in this case.
1 week, 2 weeks?
2 weeks, Your Lordship.
Highly obliged.
Highly obliged.
Good, man.
May please, Your Lordship. I beg to mention item number 31. This was the matter regarding the construction of the road in New Nongsman.
Do it today.
Your Lordship, actually, the missed case for impletement was listed on the 15th. I had not prayed for taking steps, so in the registry, without a judicious order, they're not allowing us to
Yes,
take
why didn't you?
Your Lordship, it
Should have
was
come in the. It should have come in the order. only.
missed case, Your Lordship.
My lord, if I may submit, my lord, in fact, when they had filed the impediment application, my lord, one of the contractors was left out, my lord.
No, Your Lordship, that's repeated. One person is the same person.
See, that's not a concern of the court if they left out or left in. Wrongly impeded. So when do you want it?
Your Lordship, after 2 weeks, I'll take steps to serve on the newly implemented respondents.
Okay.
18. Highly obliged, Your Lordship.
Evening, Lord.
He was there for 18. Where's Mr. Day? BSF certificate. Where's he?
We are ready, Your Lordship.
Yes?
We are ready with the matter.
You ready?
Yes, Your Lordship.
Then call him. We take it up to 15. Okay? Adul Rahman. Sasang Kutuan. Very good, yes. But the course is closing on 31st, correct? That's what your senior submitted last time. Last year admission is 31st October. You tell Dr. Muzika to be present.
Lordship.
The only issue, my lord, in this matter, whether this petitioner's area of work is in the field of, my lord, construction or not, my lord, whether he is in the engineering setup or
Why
not.
is it the only question?
Because my lord has what has fallen from my lord on the last occasion. The only issue which is required to be decided is this: whether the appointment of the petitioner is in the engineering setup or not. Now, his appointment itself speak volume, my lord, where he's in the appointment letters, it's categorically stated, my lord, that it is an engineering setup. The last annexure that we have enclosed, my lord, in our rejoinder and additional affidavit, where the DG BSF has clarified that it is a engineering setup, my lord, and his next promotion is SI work. And if you, my lord, see,
Not DG.
DG, my lord. There is an order of the DG, my lord.
What's the reply to this?
If my lord may kindly see the additional affidavit 2 dated 21st/8/2025 that we have filed. Page
59.
21st August 2025. Second additional affidavit to bring and record the letter which is issued by the DG in connection with 3 BSF personnel, that is on page 33, annexure 5. If my lord permits me to read this.
Yes.
My lord, may kindly see priority from HQ DG BSF. This is a letter which has been issued by DG BSF to Frontier Headquarter BSF Punjab. Information so and so, so and so. A promotion of HC Head Constable, Pioneer and Fitter to next.
Regarding promotion of HC, that is you.
This is similar situated person, my lord. I am also a fitter.
No, HC means
a head constable. I am also a head constable.
You're head constable.
Yes, yes.
This is in connection with your post, someone else's one.
No, this is someone else, my lord. But I am also a head constable, and I am also a fitter. Now, my lord, may kindly see the last 4 lines. As per the BSF Engineering Civil Combat Group B post, RRS 2013, from the post of SI work, BSF head constable, carpenter, so and so, plumber, welder, plumbing operator, fitter. My post is included, my lord. And the clarification which I seek for these 3 individuals, my lord, fitter's name is there. Serial number 2, my lord. So there is no question that I am out of the range of engineering setup, my lord.
Rank of SI works, HC, the various trades per stream, fulfilling of all the conditions. Okay. Okay.
My lord, they cannot deny that the DG's letter.
DG's letter can go over and above the rules also.
No, my lord. If they say, if they say, my lord,
just come back to the petition. Where's the requirement?
The requirement is, my lord,
for to pursue that. You're going, or you already finished your course diploma?
No, I want to go for diploma, my lord.
You already got admission.
My lord, they have promised me, my lord, if this month is the last.
After you get a diploma, then you get promoted.
Promote to SI work.
That diploma will take 2 years.
Yes, my lord. Lateral entry. They will give me a degree of 3 years in 2 years course, my lord.
Where is that? Is this inter-office memo?
Yes, my lord.
This clarification?
Yes, yes, my lord.
It's inter-office.
Yes, my lord.
Dr. Mozika? This one referred to just now.
Yes.
Is it inter-office memo?
This is a mail, my lord. The best like a
It's
mail.
an inter-office memo. Whatever it is, a mail might become, in mail might be physical, but it's an inter-office memo or what is it? See, what we want to know is what's the position of the department, that's all. Now you say that his is contrary to rules and that's why he's rejected. Correct?
Right.
Because you examined it, you examined his matter and then he said is not covered a rule position for grant of study leave. That was conveyed to him. Correct?
Yes.
And then so he came to before this court challenging it.
Yes, my lord.
Now and then what happens that he's produced this clarification that fitter also is fit for promotion. Then what is this other one?
Fitter, pioneer, and 2 pioneers and 1 fitter, my lord.
These documents, see.
So, my lord, let me just submit, my lord.
See, these I just want clarification on these two.
Yes,
we're given loosely, but I mean they cover everything here. Yes. First, that clarification of fitter, and second is that see the second part of that is in connection with some writ petition.
This they are saying, my lord, that the person who has issued is not authorized. Even then, if it is not, the person is not authorized, definitely we as a personnel are not that, my lord, uneducated people that someone will seek clarification and someone will give clarification.
Second page.
Yes, my lord. Here we have clarified, my lord. I'll kindly see. There is a reference to WPC number.
Something.
Now, my lord, when a writ petition is filed, I send the copy to the department, my lord. They seek comment from internal department, my lord. Then they send a pair to me. So, in the course internal consultation process, my lord, one officer said that, and he is the rank of deputy commandant, my lord.
Deputy commandant under whom, my lord, I am. He is my superior authority, my lord.
So when his comments were sought, he said that this is related to the subject. But the higher authority said ultimately the higher authority's decision will prevail, not the subordinate officers, my lord. So that is what we have taken our plea in the region.
The second page, but that is what
second page.
Petition of which court? Where is it? Punjab Haryana High Court.
No, my lord, this is a reference to the present case, my lord.
No. I have read that annexure 5, my lord, page 33, the DG letter. Even if we put aside this.
No, this is with regard to this case only.
Yes, this is related.
No, the first one, priority.
Gopal Kumar. This is also.
No.
The priority.
That additional affidavit that I have filed.
Yes, that is different.
That's the first page.
No, my lord. That is different.
Sorry.
Different. Only if my learned senior clarify on this point, my lord, whether the DG letter can be kept aside and can any other authority override his letter?
So not covered by rules. I mean, there is.
Translation of this page 3. Page 3.
No, I'm relying on this.
No, I'm just. Take out page 30. Writ petition.
Writ petition, you already filed your affidavit.
This is on page 31. 31. This is 31.
Yes.
This is not the translation you have not given to me.
You will give it now.
Well, I'll just place the facts, Mallet.
No, the thing is that now, as per the study leave, now how do you define a technical subject having a direct and close connection with the sphere of duty? That's the only thing we have to interpret, I think.
But that is one aspect, my lord. And second aspect is exigency of service, my lord.
Meaning?
If your lordship kindly takes up my affidavit, my lord.
Why exigency? You want to improve himself to come for promotion?
No, he can improve, my lord, but his improvement should be of any public benefit, my lord, in the interest of the department. I'll just place my affidavit. I have quoted the rules, my lord.
Okay.
The affidavit filed in April 25. First main affidavit.
April?
Yes,
11 April.
Yes.
The page 4, my lord.
Yes.
Subparagraph, I have quoted the rules, my lord. These are CCS leave rules 1972.
Yes.
Rule 7 says, my lord, is overriding that leave cannot be claimed as a matter of right.
Yes.
Then it says, my lord, when the exigencies of public service so require, leave of any kind may be refused or revoked by the authority competent to grant it. So that's the main thing, my lord, that overall discretion remains with the department. And they have no, it is not a matter of right. Then rule 50, my lord, on the next page. Subject to conditions specified in the chapter, study leave may be granted to a government servant with due regard to the exigency of public service to enable him to undergo in and or out of India a special course of study consisting of higher studies or specialized training in a professional or technical subject having a direct and close connection with the sphere of his duty. Then my 3 small I. It is certified by the authority competent to grant leave that the proposed course of study or training shall be of definite advantage from the point of view of public interest. Then rule 51 is relevant, my lord. Towards the bottom, the maximum amount of study leave which may be granted. Ordinary shall 12 months at one point of time. During his entire service, 24 months in all, inclusive of similar kind of leave or study or training granted under any other rules. For health, personal wise, a different left it out. So the overall scheme remains, my lord. He has no, is not a matter of right. Discretion is with the department, taking into account the exigency of service and the public interest. It will serve. It will send on department. Because this is mainly because, my lord, they are seeking paid leave, my lord. Government has to pay the full salary for the training period, my lord. If he is going without pay, my lord, the consideration would be different.
Go without pay?
As per the law, if the law permits me to get some amount of payment.
See, the discretion lies with them. You have to understand.
There is no doubt about it, my lord.
See, they can bring out any excuse or exigency of your right is circumscribed by the authority granting the leave, correct? So now if they say that they're ready to give it out without pay, half pay.
My lord may kindly consider. My lord may kindly consider if my learned senior come to the core issue, he's not coming to the core issue, my lord.
No, wait a minute. He's just warming up to the core issue. He's going to issue.
At this age, my lord.
No, my lord, here going through the rules, there are 2 hurdles, my lord. At one point of time cannot be given more than 1 year, my lord. His course is of 2 years. So even that discretion because the rules say that at one point of in one stretch it can only be 1 year. Admitted position, his course is going for lateral entry of a diploma course, which is a 2-year course. So we have to sanction 2 years leave, my lord, which is against in violation of rules. We cannot do that, my lord, in one go. After 1 year, he has to again apply, my lord. Then again, depending on the parameters, extension will be given to him. So we cannot
take continuation same leave. That will be the length of service for 2 years.
My lord, we cannot. The rules say that cannot be more than 1 year.
You have no authority on this.
The rules are so clear, my lord.
Rules can be bent also in such a manner if there have been some consideration. Anyway, next point.
So, considering all these factors, my lord, and also considering mainly that having a direct or close connection with this payer of his duty. That is second aspect, my lord.
Okay.
So
now it's proven that fitter as a course of duty is part of engineering setup.
Well, that aspect is subject to like lordship can look into that. But the first obstacle on our way is, my lord,
the rules don't allow.
It is not in the exigency of public service, my lord. And this decision has to be taken by the authorities, whether they require further training of any personnel or they don't require it, my lord.
Yes.
So taking this overall scenario, my lord, the department rejected, and the rejection order is at page, the last page of the writ petition, my lord. This is 28 November 24. Page 44. 28 November 24. The last page of the writ petition, page 44. It says, my lord, has been rejected, last sentence, by the competent authority for not falling under the rules for study leave. So, my lord,
so you mean to say that the other clarifications, I think, has no meaning?
My lord, even if it is within that specialized field, or even if it fulfills that, my lord, there are two more parameters that leave cannot be more than 1 year at a go, number one, and number two, he has no right to take leave. It is for the authorities to take a decision, and authorities have to take a decision whether sending him.
So you mean to say as twofold? Even if he satisfied the technical requirements, even then is your part of 51.
My lord, if the department is satisfied that they require, yes, an engineer is required in the department, then only, my lord. And the department thinks that they are doing only border fencing repairing, my lord. They don't require civil engineering diploma.
Who's doing border fencing? Doesn't require the pumps and the.
That was what they have pointed out in the initial stage. When I brought out all these documents, now
it's basically fitter, my lord.
Fitter means fits what? What's your
because what,
my lord, I am taking care of the border fencing, my lord.
Border fencing one.
I'm taking out of border fencing, construction part.
Some repair border fencing, my lord. That
it's not that some repairing, my lord. The entire thing is on me, my lord. I go and examine, my lord.
Border fencing.
Yes, my lord.
On you.
Not only me, my lord. There is a setup. I'm taking care, my lord.
No, we understand. See, we're looking just whatever is both seeing is just whether you come within the whether it can be considered or not.
Yes,
that's all.
Yes.
And if you have produced that document saying that fitter the line of duty.
Yes.
But then Dr. Morsika said that it might be in line of duty also, but if there's no exigency, number one, and number two, if you can't overcome Rule 51, then sorry.
Yes. Then how do you overcome? I will satisfy, my lord.
So, my lord, it's for the department to know or to appreciate whether they require a civil engineer for that or if fitter is enough for that, my lord.
It's okay. I mean, that's the thing, my lord.
If my lord senior finish wind up,
that's the only point.
My lord, first, my lord, may kindly see the rule 50. My lord, rule 7, what my learned senior has pointed out. Rule 7 from his my lord, right to leave. There is no dispute that to go on leave, my lord, is my right. It is for the discretionary of the department, my lord. That is not a question, and that is not we are hesitating that, my lord. That is my right. That is not my right, my lord. To consider me for promotion is my right, my lord. Whether I get a promotion or not, that is also not my fundamental rights, my lord. Second thing, my lord, that stretch of 2 years I cannot take, my lord. Let them give me 1 year, my lord. If the second year, my lord, they want to reject, let them reject.
How is that possible? If
for 12 months, I am entitled.
It makes no sense.
My lord.
It makes no sense. You can't give the kind of relief. Say, okay, fine, give him for 1 year.
Can they be pick and choose, my lord, for the department?
See, if the course goes just 2 years, 2 years.
No, I'm not saying
some abridged course.
No, I'm not saying that, my lord. What I'm saying is this: can a department pick and choose that? Okay, fine, for Mr. A, I will allow. Mr. B, I will not allow. Now, the law can be interpreted in many ways, my lord. Now, this is not the discretionary power of the department to interpret the law whichever it favor them, my lord. That cannot be permissible. That is why I am before this honorable court. My lord, they can give me a leave for 1 year. Then, my lord, I can apply again. That will be a subject matter of scrutiny of this honorable court also, my lord. If they reject.
What's the point that you 1 year, then if it's
definitely, my lord. For others, they have given.
Sure,
my lord.
That when you go for reconsideration, they're not going to give it to you.
My lord, they have given to others. I have enclosed those documents.
Others, without any litigation.
It's not about without a litigation, my lord. If they are not even appreciating the letter of the DG BSF, my lord. That is the unfortunate where a subordinate is not even appreciating the letter which has been issued by the topmost of the BSF authorities. My lord, I'm just coming to the rules, my lord, and I have also given my written argument, my lord. My lord may kindly consider this.
Written argument?
Yes, I have given my written argument that because there is all hodgepodge, my lord, too many affidavits, too many rejoinders and all. If again, my lord, I will come to rule 50, my lord. Rule 50 says, my lord, subject to the condition specified in this chapter, study leave may be granted to the government servant with due regards to the existence of the public service to enable him to undergo in or out of India any special course of study consisting of higher studies or specialization training in a professional or a technical subject. I am for a technical subject having a direct and close connection with the sphere of his duty. Now, it is an admitted position by now, my lord, is that it is a direct connection with the sphere of his duty, my lord. There is no dispute about it, my lord. After that, letter of DG has been placed before this honorable court, my lord. Whether it will be of any importance or not, my lord, the authority under whom I am serving, my lord, who is issuing me a movement order to go and inspect, my lord, he has clarified that whether it will benefit the department or not, my lord. That letter, my lord, has shown just now, my lord.
No, it does show exigency. It just says that deployment is close connection with the sphere of duties of HC fitter.
Yes, and the letter which my lord has just shown, my lord, that the writ petition in connection with my writ petition, where my authority under whom I am serving, my lord, what he has specified. Yes, my lord.
Yes, he said only like it's connected with the sphere of duties HC fitter.
No,
granted connected.
Yes, my lord. The next question, my lord. The next answer.
Agreed means.
What was the question, my lord? The question was whether it will be a benefit to the department or not.
Whether civil engineering is capable of widening the mind of any HC fitter in a manner likely to improve his abilities and shall equip him better to collaborate with those employed in other branches of the public service. Says agreed.
Yes, he agreed with the proposal.
Exigency is met.
Yes, my lord.
Okay, then.
Now, again, coming back to the term of 12 months, my lord, they can give at one shot 12 months. Subsequently, they can also give me another 12 months, my lord. That is, in service, my lord, I am entitled for 2 years. I am not praying to them, my lord, that to give me a leave for more than 2 years, my lord. Only for 2 years. Initially, my learned senior has tried to bring out lots of hurdle, my lord, that whether 3 years course, how he will complete in 2 years. Now I have shown there is a lateral entry. The university is giving me.
See, the maximum amount of study leave if granted to government servant is 51 and central health servant only 12 months.
12 months. And which may be extended, my lord.
Where is that given?
Then, my lord, ordinarily in page 7 of their affidavit, my lord, ordinarily 12 months at one time and during his entire service 24 months in all inclusive of similar kinds of leave or for studies or training granted under any other rules. So it is not the case, my lord, they can only grant me 12 months only. At a stretch, they can give me 12 months, another stretch, my lord, another 12 months, my lord. So, my lord, my written argument that I have placed, my lord, that may be considered before passing this order, my lord, whatever order comes, my lord.
Yeah, Dr. Mazgar, no authority.
I'm not carrying. Lordship permits, I'll file a synopsis along with.
No, just give authority tomorrow.
Some authorities.
By tomorrow? Yes, sir.
Only one submission, my lord. The leave in question, my lord. Lordship will see. It is for 24-26. Though
So what happened now?
Though I'm not saying that for 25-27 department is agreeing to give, but whether the 24.
my lord, is blowing out. Picture now, okay. Can you disregard that recommendation of the DG, that fitter line of duty? That I think this court, I don't think you can say otherwise. Fitter is in continuation of this, like civil engineering kind of work. Now the only other question is your rules, whether they contain a flexibility, like where he can maybe complete the course.
The word used is shall, my lord. It's not even.
No, it's used ordinarily. Ordinarily, not more than 12 months will be given.
Yes.
Correct. So let him take his chances. You give him for 1 year, then you see.
My lord is enlightening my.
Then he can be a dropout civil engineer.
It says ordinary 12 months at one time.
Ordinary.
And clause B.
No, it's all right. I mean, we've seen that. I mean, whether those rules, that's only with one thing. That's one authority. Whether allow the flexibility, that's the only thing. If it's rigid, then.
But that's one aspect, my lord, and the other aspect, my lord, the internal document which has been issued in the process of filing an affidavit before this honorable court, my lord.
No, we can't.
And he's having access to that.
Whatever that one given by your superior, that's in the matter is already filed, correct?
Yes. No. My lord, may kindly appreciate.
He should not have access to that document.
No, my lord, may kindly appreciate.
Please answer the question.
Yes, my lord.
Was that clarification given after it had been filed, right? It's 486 mentioned there.
Yes.
Can I submit, my lord? My learned senior is twisting. My lord. Yes.
Yeah.
Who has seek for the clarification? I am not the one who has seek for the clarification. It is a department.
You saw clarification.
They have seek a clarification, my lord.
It is interdepartmental clarification, my lord.
That's fine.
My lord, how can I?
Now in case of like once what happened.
In his case, he should not have access to his documents, my lord.
That my lord, they can do whatever they feel like, my lord. Second thing, my lord, if this document would have been against of me, they would have come and bang me on this document only, my lord. See, his authority has said he has no.
Regarding the Charter of Duties, there's no quarrel. That the document, it neither helps them, helps you. So it's fine, because the fitter is in the line, it's line.
But the charter will file an affidavit. The Charter of Duty is there, my lord. The fitter's job is carry out repair work of border fencing. Will change MS plates, angle iron of operation towers and fencing.
Yeah, that is all
construction. Will do work of drilling in angle iron. So civil engineering is not required.
So he's just a blacksmith.
Basically blacksmith.
So he want to appoint me and he want to kill me there only, my lord, without any promotion.
Think about the financial implications.
And it's a
only for me, my lord.
How much are you drawing now?
I have no idea, my lord. I have transaction.
It's a paid leave, my lord, for 2 years.
Subject to the rules, my lord. If I am entitled by the rules.
Anyway. Won't you be happy to have a more qualified person?
But there are higher posts, there are qualified people, my lord. There are engineers.
You can assist engineers better. all this confusion and border fencing is happening. Then we'll examine. Just give authorities where you see it's not permissible for any relaxation. That was 50 and 51.
Either way, whatever I'll place it.
Yes. We'll list the day after tomorrow then, Tuesday. For further hearing on Thursday, give you 1 day.
Only for the authorities, my lord.
Let your juniors do research.
Deep.